Good morning to all of you. అందరికీ శుభోదయం. Happy Sunday. Welcome to Legal Matters by Sai Baba Sukha. Honorable Supreme Court of India, two judges bench, Justice Abhay Srinivas Vakha and Vijay Bayan, in the case of Sekhawat and another versus State of Uttar Pradesh, criminal appeal number 457 by 2024, on 23rd May 2025, recently observed that the trial courts are being nomenclatured, are being called as the lower court, which is not correct and which is against to the constitutional ethos. There is no lower court, there is no higher court. Every court is equal. Judicially, the magistrate can give judgment of his own accord. The judge can deliver the judgment. High court also can deliver the judgment basing on the three principles of justice, equity and good conscience. That's all. There is no inferior, there is no superior. But normally, people used to call it the trial court as the lower court. In one of my previous videos also I discussed that there are district courts and kuda constitutional untundi. It's not correct. Anyway, Supreme Court said that don't call the trial courts as the lower courts. Call them as the trial courts. It's better. In February 2024 itself, Honorable Supreme Court of India has given directions and the Supreme Court registry also has sent the same. But still, by usual, the dint of practice, they are telling the so-called lower court. In the professional ethics or while dealing with the Advocates Act, I have been telling you that the person who is enrolled with the Bar Council of a state, he should be called as an advocate. The other synonyms cannot apply to him. You can't call him as a lawyer, you can't call him as a pleader, you should call him as an advocate. But you go and see in the courts, my pleader can పిలుచుకోండి, మీ లాయర్ గారు రాలేదా? Even judges also will say, అలా జరిగేది అంతకన్నా ఏం లేదు. ఎనీవే, ఈ సందర్భం వచ్చింది వేరు, కేసు వేరు, ఈ సందర్భం వేరు. దీనికోసమే ఈ జడ్జిమెంట్ కాదు. The case of Sekhawat, actually, this is an appeal against the judgment of the Allahabad High Court, and is relating to an FIR which was registered in the year 1981. Oh, 81 was a murder case. Sekhawat was figuring as A2 in the particular case. What happened is, on the intervening night of 4th and 5th May, అంటే 4-5 తెల్లారితో 5 అనగా 4th/5th May 1981, Sekhawat and two others, they went into the hut of the deceased Sukha. Name of deceased Sukha, who was sleeping in the hut. Of course, he was having with some, presently we can call he was having some illicit contact with a woman, PW7, Nanhi, Nanhi, shot him to death from close range. And the allegations against this particular Sekhawat is that he inflicted knife injuries to the deceased person also. Besides the arm shot, besides the firearm shot, he has inflicted knife injuries also to see that doubly careful that he dies. Right. So in this connection, FIR was registered on 302 read with 34 IPC, and the police promptly arrested these people. But an important development now we have to observe. At the time of bail petition, Sekhawat has filed, or the witnesses, 4 witnesses filed affidavits stating that Sekhawat did not inflict the knife injury and they did not see the accused assaulting him అని చెప్పి వీళ్ళతోనే తిరగబడేటువంటి హాస్టల్ అయ్యే స్టేట్మెంట్ లాగా ఎఫిడవిట్ ఇచ్చారు ఎట్ ది స్టేజ్ ఆఫ్ బెయిల్, basing on which the bail was granted. That's one part. The police ignoring the affidavits, ignoring the value of affidavits. That means without examining the witnesses regarding the affidavits, they have filed the charge sheet. The trial court also did not observe the same. They convicted the accused to life sentence. A3 was acquitted. A1 and 2, they were given life sentence. Now, High Court has approached the High Court. High Court also confirmed the same. And now the matter has come to the Supreme Court. Please remember, Supreme Court has gone to the entire record. And please remember, the important point is, no doubt, we know that PW7 is having illicit contact, or the deceased was having illicit contact with PW7. She turned hostile. She said that some other PW4 wanted to kill Sukha, like that. She turned hostile. Second point, Amin Hussaini, PW7 I think, PW4, he is the direct witness or eyewitness to the incident against whom this woman, PW7, wanted to throw the blame. And there are much contradictions in the statements of the witnesses, particularly PW6 and 7. There is delay in the FIR. When the incident took place at 2 p.m., the FIR was registered at 6:30 p.m. on the same day. Even though it is a nearer place, there was delay. So, please remember, and there is evidence, of course, PW5 identified A1 to A3 before the court only. No test identification period was done. So, of course, even PW5 stood, there are no material contradictions in his cross-examination. But the important point is, the affidavits at the time of bail, nobody is bothered. When the IO was cross-examined regarding the bail affidavits, whether you cross-checked them, he said no, he didn't have knowledge. How he didn't have knowledge? It's on record. It's based on record. Doesn't he know that? Of course, enduku chesado last lo cheptanu. So, IO says he did not know the veracity of the affidavits. This is a lacuna. Right? So, the cross-examination of the IO, PW10, which has become crucial, that he suppressed the material regarding the affidavits. Tills kuda vadilesadu. And High Court and Sessions Court did not observe this. So, basing on the affidavits, when they say that they have not committed the offense, now how can you say that they have committed the offense? Affidavit lo clear ga ist. Affidavit ante enti 139 CRPC lo meeku cheppam. 139 CPC. Affidavit is a sworn statement given to the court with a signature, basing on the facts which are known to you. అది ఎక్కువ 161 ఎక్కువ వస్తే అఫిడవిట్కే ఎక్కువ వాల్యూ ఇచ్చి of course the case ended in acquittal. He was released, ordered to be released, bail bonds to be cancelled, appeal succeeded. In this connection, the Supreme Court said that already we have told you that don't call it as lower court, call it as trial court. ఇక్కడ lower court అని రాసుకొచ్చారు హై కోర్టు వాళ్ళు. ఇట్స్ నాట్ కరెక్ట్ అని చెప్పారు. But a good suggestion or good directive from the Supreme Court, better to follow. Nobody is superior, nobody is inferior. Okay, if you understand this much, it is sufficient. Thank you.